Divorce mediation and divorce litigation are entirely different, and they're different because of their approach. In divorce mediation, the spouses work together with a neutral third party outside of the courtroom to resolve issues that would otherwise have been determined by a judge. In the mediation, the parties work together to resolve these issues together. They create a document called a stipulation of settlement that tells the court what the parties want to happen to their children, their assets, and any other issues that otherwise would have been determined by a judge. Additionally, mediated divorces tend to be much quicker than litigated divorces, specifically because you're only dealing with the schedule of you and your spouse and the mediator's schedule, as opposed to a court calendar, which can be much lengthier. And because there's no trial, the impact that the divorce has on the family tends to be a little bit less. But mediation only works when you and your spouse can be on the same page to reach an amicable agreement, so it's really not for everybody. On the flip side is divorce litigation. In divorce litigation, the parties have their own individual attorneys, whose job it is to represent their best interests. The parties do not work together to effectuate one universal agreement. Instead, they want to advance their positions and have the judge decide what will happen to assets, what will happen to the children, what support will be paid, etc. No matter which approach you take, you need to make sure it's the approach that works for you and your family and for the interests that you want to see happen in the end. So take some time and explore our resources. Look at the website, sign up for our newsletter, listen to the podcast. There's certain to be information there that will help you in this. And better yet, come in and we can evaluate for you and with you which approach might be best for you and your family.